Hello everyone, my name is Noor Magnawi. I'm practicing instructor at the Criminal Justice Department at Camosun College, Victoria, BC. So my first question to you, are you aware of your legal rights if you are under arrest, searched, or you are prosecuted for allegedly committing a criminal offense? This presentation will present to you your fundamental legal rights that are guaranteed to you under the Charter of Rights and Freedoms. Canada is a constitutional democracy based on the rule of law, where the civil rights and liberties of all Canadians are protected and must be respected by all levels of government. The first attempt to list the rights of Canadians in a legislation was in 1960 when the former Canadian Prime Minister's government, John Diefenbaker, enacted the Bill of Rights. However, the Bill of Rights did not have the legal supremacy and therefore it was not fully respected and implemented by all levels of governments in Canada. Therefore, in 1982, the Canadian government included the Charter of Rights and Freedoms in the Constitution. In 1982, Canada patriated its Constitution, meaning before 1982, if Canada wanted to amend the Constitution, it had to request the approval of the British Parliament. As you see in this picture, the Queen signs the Constitutional Act in the presence of the former Prime Minister Pierre Elliott Trudeau. The Canadian Charter of Rights and Freedoms is a part of the 1982 Constitutional Act, meaning it is part of the Canadian Constitution, which means again that the Charter has the legal supremacy and must be implemented and respected by all levels of government, including the private sector, companies, organizations, and non-profit organizations. The Charter includes the fundamental rights such as mobility rights, language rights, religious rights, and legal rights. Canada is a multicultural society, and the Charter of Rights and Freedoms protects this diversity. So no one could be subject to discrimination either based on gender, race, country of origin, or any form of discrimination. The Criminal Code of Canada defines the criminal offenses and also designates the sentence for each criminal offense. And the police in Canada enforce the Criminal Code and other federal and provincial statutes. When we talk about policing in Canada, we have 4 levels of policing. We have the RCMP as a federal police, and we have provincial police in Quebec, Ontario, and Newfoundland. And also we have the RCMP acting as provincial police based on contracts with provinces such as here in British Columbia. And we have regional policing, and at the end we have municipal policing. The police in Canada has the authority to stop, detain, and arrest individuals if they have reasonable grounds that they are involved in illicit activities. Otherwise, it will be arbitrarily arrest or form of racial profiling. Section 9 of the Charter of Rights and Freedoms says everyone has the right not to be detained or imprisoned arbitrarily. The police need to get an arrest warrant in order to arrest someone. And in order to get that, they have to request that from the Justice of the Peace, where a police officer has to swear under oath that the allegations that are brought against the person are valid. However, under some circumstances, the police don't need an arrest warrant, as we said, if they have reasonable ground, or if they caught the person committing the criminal offense, or they believe that the person has committed a serious indictable offense, or they believe that the person is about to commit an indictable offense, or if the person is involved in terrorist activities. The police also has the authority to stop and search individuals, their vehicles, and their houses if they have reasonable doubts. Otherwise, they would need a search warrant. Section 8 protects Canadians from arbitrarily search and seizure. Section 8 states everyone has the right to be secure against unreasonable search or seizure. In order to get the search warrant, the police will need again to swear before Justice of the Peace that the information that's brought against the person are valid, and therefore they need that warrant. And that it is up to the justice of the peace to grant them that warrant or deny them that request. If the police are granted the search warrant, they need to conduct that search in a reasonable way, so in a respectful way according to the law. If a person is charged for allegedly committing a criminal offense, then that person is innocent until proven guilty. Section 10D of the Charter of Rights and Freedoms says everyone has the right on arrest or detention to be presumed innocent until proven guilty to law in a fair and public hearing by an independent and impartial tribunal. Everyone has the right to be tried in a reasonable way, in a reasonable time, and in a fair trial, according to Section 11 of the Charter of Rights and Freedoms, and it is up to the judge to decide the merits and the validity of those charges. If you are charged with a criminal offense, the court has to determine the validity of the charges against you, and also has to determine that in a reasonable time, and a person has the right to have a jury, members of his community in the jury. Section 11F of the Charter of Rights and Freedoms says everyone has the right to benefit of trial by jury where the maximum sentence of the offense in case of conviction reaches 5 years. If you are found guilty of the charges either by a judge alone or by the jury, then the judge has to decide the sentence. In order to protect the rights of individuals and have fairness, members of your community have to be part of the jury. If a person is found guilty, then the judge must decide on the sentence according to the law, and that person must be sentenced twice and not to be tried again for committing the same offense. If the person, the accused, is found not guilty, then that person must be protected from being tried again for committing the same offense. As you have seen, we have a number of rights that are guaranteed to us by the Charter of Rights and Freedoms. However, the Supreme Court of Canada plays a major role interpreting the Charter of Rights and Freedoms. So sometimes the Supreme Court interprets the Charter in narrow sense, which limits those rights, and sometimes else it interprets the Charter in much more larger sense and grants us more rights. So, for example, if you look into the Section 10 of the Charter of Rights and Freedoms, it states everyone has the right to remain silent and instruct counsel. However, Supreme Court decision in R versus Singh in 2007 affirmed that the police can continue to question a suspect at length even though the suspect repeatedly tries to invoke his or her right to silence. Again, Section 10 says everyone has the right to instruct counsel. However, Supreme Court decision in 2010, R versus St. Clair, says that the presence of a lawyer is not required during interrogation. So as you have seen, we have a number of rights that are guaranteed to us as Canadians, but it is up to the Supreme Court of Canada to extend those rights or to limit them. But also it is your obligation to know your rights, because if you are arrested without a warrant and you fail to share that with your lawyer or to disclose it in court, then it is your loss. If you are arrested by the police but they didn't inform you of your rights, if you share that with your lawyer or you share that in courts, that can lead to the dismissal of your charges. If you are arrested and searched without warrants and you fail to dismiss that, to share that in courts, then it is your loss and you will be convicted. But if you mention that the search was not legal, was without warrants, then actually that will lead to dismissing the charges. So being aware of your rights protect you. I hope you find this presentation informative, and I welcome your feedback. Thank you very much.